Okay, good evening and good morning to Madam Jatun Naim. Today we're going to talk about the erosion of the concept of the constitutional supremacy in Malaysia. So, to start it all, as mentioned above, the title of the article that has been chosen for this particular assignment is the erosion of the concept of constitutional supremacy in Malaysia. So the article is written by five incredible authors, which are Nur Ashikin Hamid, Kamalia Saleh, Nur Aida Harun, Asia Bidin, Nazim Ismail Awang. And although this particular article was accepted in 22nd of February in 2019, it was officially published on 10th July of 2019. An Australian academist and author named Kenneth Ware defined constitution as a whole system of government of a country, the collection of rules which establish and regulate or govern the government. Furthermore, Professor Eric Barron defined constitution as a power map which organizes political authority so that the power will not be used in a way that can result in oppressiveness and arbitrarily. Furthermore, Merriam-Webster.com dictionary defines constitution as a foundations and organic law of a nation or state that establishes the institutions and framework of a government, determines the scope of governmental sovereign powers, and assure individual civil rights and civil liberties. In Malaysia, however, the term constitution is used in two senses, which are as a body of legal and non-legal rules concerning the government of a state, and secondly, as a single document having special legal status which entrench the state and lays out the structure and powers of the state. Supremacy, on the other hand, is translated as the position of having the superior or greatest power or authority. To sum it all up, it can be seen and said that constitutional supremacy is the position of the constitution having the superior or highest power or authority in a specific government. I will pass the mic on to Iqbal.
Okay. Article 4, bracket 1 and 162, bracket 6 of the Federal Constitution and Section 73 of the Malaysian Act 1963 define constitution supremacy. In Ahtiam versus Government of Malaysia 1976, it was stated that the notion of parliament supremacy does not apply in Malaysia. We have a constitution. The constitution limits the power of parliament and state legislature in Malaysia P 113. As stated in Article 4, bracket 1, this constitution is the supreme law of the federation, and any law passed after Merdeka Day, which is inconsistent with this constitution shall be void to the extent of inconsistency. However, Article 162 bracket 6 of the Constitution refer to pre-medical law. According to Datuk Sri Sami Velu versus Nadaraja 2001, Article 4 bracket 1 and 162 bracket 6 of the Federal Constitution take different approach to constitutional inconsistency. The supremacy of the Constitution is upheld in Malaysia through the judiciary. The first is known as the ultra-viral virus-based hypothesis, Craig's 1988. It examined the executive directionary acts in applying legislative restriction as well as the compliance with the common law and other constraints, including rationality and fairness. The second type of judicial review recognized the primacy of a written constitution, allowing higher court to evaluate initial legislation for constitutionality. A law may be declared unconstitutional for the following reason. Hamzah 2009, first under Article 128, bracket 1 of the Federal Constitution, only the Federal Court can declare a law unlawful. In this sense, the Federal Court has jurisdiction to decide whether a law passed by Parliament or the state legislature is unlawful because it deals with a subject that Parliament or the state legislature has no capacity to legislate. Second, it was not enacted in accordance with the Constitution procedure. that it violates the Constitution. Finally, state law conflict with federal law. The federal constitution provides that if a state law conflict with a federal statute, the federal law prevails and the state law is void.
How it is applicable within a country state. The erosion of the concept does occur in reality as the concept of supremacy claimed to apply in Malaysia. Article 4, Clauses 1 and 162, Clauses 6 of Federal Constitution provide the concept of constitutional supremacy as well as Section 733 of Malaysia Act 19,063. There are a few of following factors. Started with the special powers of Parliament to legislate to counter emergency and subversion. For example, during emergency, except for a limited scope of matters, emergency laws passed during emergency are considered valid even if they are inconsistent with provisions in the Constitution and it's only applicable to matters related to religion, citizenship, language, Malay custom, and native law or custom in Sabah and Sarawak as specified in Article 150, Clauses 6A of the Constitution. Further, since independent, the case with which constitutional amendments of the constitutional clauses 1 declares that subject to the following provisions of this article and to Article 161E, the provision of this constitution may be amended by federal law. It prescribes 4 different methods for amendment of the different provision of the Constitution. Moreover, judicial attitudes in the interpretation of the Constitution are also one of the following factors. It leads to erosion of constitutional supremacy is related with constitutional interpretation and the court may declare it ultra vires and void if a legislative or executive act violates the Constitution. Lastly, safeguards and caveat contained in the Intergovernment Commit and the Malaysia Agreement 1963. In accordance with the studying of the Intergovernmental Commit, Great Britain and Federation of Malaya report, hereafter is referred to as IGC report, 1962 and the Malaysia Agreement 1963, it was revealed that the provision of both documents may defect the concept of constitutional supremacy in Malaysia.
Example or support with cases, for example, based on Muh Khairul Azam and Menteri Pendidikan East Malaysia, the application of leave to comment proceeding under Article 4, Clause 4 Federal Constitution. This provision allows for a case to be brought to the federal court and be heard in the exclusive original jurisdiction of the court under Article 128, Clause 1 Federal Constitution. As a starting point, it is important to highlight that leave referred to in Article 4, Clause 4 is leave to bring a matter before the federal court in its original jurisdiction. In the main, the federal court is an appellate court. Its exclusive in original jurisdiction is very limited. It was argued that Article 152 Federal Constitution does not empower Parliament to do so. The issue raised by the applicants was whether the provisions of the Education Act were inconsistent with constitutional provisions. It was held that such a challenge could not be heard by the federal court at its original jurisdiction. For a matter to be determined by the federal court in its original jurisdiction, it was observed that the challenge must be targeted at Parliament legislative competence to enact impugned provisions. For the next cases, Loh Koi Chun and Government Malaysia, Before the Federal Court, Law Council argued against the amendment and its retrospective effect on the grounds that it was not permissible for the Constitution to be amended in such a way that its basic structure was destroyed. Law referred to Article 4, Clause 1, which specifies that the Constitution is the supreme law of the Federation, and to the basic structure doctrine of the Indian case law to argue that the amendment had contravened the spirit and basic structure of the Constitution by invalidating the right of habeas corpus. The case has been criticized by the legal scholars who have argued that it effectively gave the government free rein to pass unconstitutional law. One part of Raja Azlan Shah's judgment, which states that individuals certain fundamental rights upon which not even the power of the state may encroach, was subject to criticism from hardly holding substance. In light of certain legislation, such as the RRE and Internal Security Acts, which is ISA, that allegedly encroach on human rights. This part of the judgment in law has been described as no more judicial rhetoric. Legal scholars have been suggest that the decision in law made Article 4, Clause 1 is sufficient with regard to ensuring the constitutionality of laws passed by the Parliament, as instead of bringing the impugned legislation, the RRE, into the accord with the Constitution. It was the Constitution that was brought into June. The RRE was accorded a supreme position over the Constitution in regard to arbitrary arrests and restrictions of movement just because the authorities forget to apply Article 5, Clause 4 in the course of arresting and detaining a subject. Next, I will pass the conclusion to Lash.
The concept of constitutional supremacy is provided by Article 4, bracket 1 and 162, bracket 6 of the Malaysian Federal Constitution. It is contrasted from the doctrine of supremacy of Parliament as drilled in the English Statute. The target of this paper is to concentrate on the idea of constitutional supremacy, why it has become vital, and the perils that it presents, assuming there's a disintegration of the concept. The review depends on doctrinal exploration, as it is essentially concerned about the survey of the arrangements of the Constitution and detailed cases that have been chosen by the courts. It is proposed that it was workable for Parliament to alter the Constitution to a point where it essentially may surrender the idea of constitutional supremacy in Malaysia. Thank you.